you all again for joining us. We thank you so much for joining our Lunch and Learn meeting today. We have a great meeting in store, a great presentation, and we're very excited to have Sarah Sullivan joining us. And so I'm just going to give a brief intro of Sarah. It's actually a pretty good intro of Sarah, and then we will get started. So again, thank you all, and thank you, Sarah. Sarah Sullivan serves as the Vice President of Advocacy and Family Support at the Arc Jacksonville. She's since 2021. So Sarah has created and implemented the Life Path Planning and Management Program at the Arc Jacksonville, the first program of its kind in the Northeast Florida. The program designed to support caregivers and provide management services for persons with intellectual and developmental disabilities. Utilized Sarah's knowledge of legal systems, public benefits, and the needs of caregivers. She spent the first 24 years of her legal career as a public interest lawyer with an emphasis on advocacy for persons with disabilities and special needs. She chaired the public interest law section of the Florida Bar in 2016-2017, and during this year, the public interest law section sponsored the first juvenile law certification review course leading to the first class of board certified juvenile law practitioners. She is a member of the Florida and South Carolina State Bar Associations, as well as the Federal Middle District of Florida and the United States Supreme Court. So Sarah, with that, like I said, if you need anything during this meeting, you just let me know. I will monitor the chat. Please, if you all do have a chance to unmute, please be respectful to those who are speaking and make sure we're not interrupting anybody. And we will have time for questions at the end. And if Sarah would like to take questions during the meeting, she can just let me know and we'll make that happen. So Sarah, thank you so much. You can take it away.
Thank you. And I would like to hold questions until the end, only because I may answer your question while I'm going forward with the slides. And I also know that I love to meet the needs of the people that are in the room. But sometimes I'll get stuck on slide 5 and I won't get to slide 15. And slide 15 is some really good information. So and that's just an example. So if we could just hold it, and if you have any technical issues, raise your hand or put it in the chat, and we'll kind of go from there. But thank you everyone for having me. I love presenting with and for ARC Florida, and the opportunity to share kind of this information statewide. So today we're going to be talking about decision making and the services cliff. And the services cliff of something, it's kind of a phrase that has come up in the last several years. And what it refers to is when a person is moving from childhood to adulthood and then through that 18 to 22 phase, there are benefits that fall away and benefits that can be applied for. And there's notifications that need to be made by caregivers. And most of that can't be done unless you have decision-making authority. So part 1, which is today, is going to be talking about decision-making authority. And then we're going to do a deeper dive on Social Security issues, which really should, if you're not on SSI as a child, usually applying at 18 years and 1 month is the best way to do it. And there's many reasons for that. I should say also, if it doesn't come up, if you are a caregiver or are a person that's 18 or over and you don't have this decision making, it is never too late. When I was practicing and I came to the Arc Jacksonville, I think we went to the West Side location. I was doing a training over there, and a parent came up to me and her son was 40 years old and they never had any decision-making authority. And so it's not too late. They were able to get guardian advocacy for their son. They did absolutely need it because he was starting to have some chronic health issues which required specialists. They had kind of been able to do things kind of under the radar because they lived in the same community, had the same caregivers, gone to the same primary care doctor. And so it never came up until he was in his 40s. So that only to say that it's never too late, but the sooner the better if you can. With that, let's get started. Let's jump in. So some day is not a day of the week. I put this in because I get it that this stuff is complicated, it's hard, it is, caregiving for your loved one or navigating this stuff as a self advocate is confusing. So, going and planning and doing all the documents and all that kind of stuff, it's usually gets put on the back burner. And just to make you feel a little bit better, I'm an attorney. I do this kind of work for a living. We recently retained someone to do our estate planning documents because you're really not supposed to do your own estate planning documents. And our last version of estate planning documents were done when my son was 3 or 4 months old. And guess how old he is now? He's 20. All right. So everybody puts this stuff off. All right. Even attorneys that are in the biz. So don't feel bad. In fact, I'm even postponing. My husband keeps on saying, are you going to email the lawyer to tell him what you want to change? I'm like, yeah, I'll get to it. So I understand it. I get there. I get it because I am there. So where do you begin? I like to kind of talk about decision-making authority and the age because a lot of people really feel like if they are parents of a person with a disability, that they just kind of always end up having the opportunity to make decisions for them. And that's not the case. In the eyes of the law, once your child turns 18, you no longer have that decision-making authority. There might be people, like I mentioned before, doctors or maybe caregivers, that just are used to assisting you as the parent. But in the eyes of the law, you do not have decision-making authority once they turn age 18. So no matter what their, intellectual capability or understanding or, no matter what, they, in the eyes of the law, have the ability to make their own decisions. So there are tools, which we're going to talk about today. And it really, there is no one size fits all. I just recently, actually the last couple of days, I've been at a health justice conference with other public interest lawyers that do this kind of work. And oftentimes, these are like your civil rights lawyers, and they're like amazing, intellectual, super smart attorneys. But sometimes I feel like there's this push to never have a guardian advocacy or only use, this, that, or the other. And I always say it really depends. It depends. You always want to use the least restrictive means of doing things. You don't want to take away or confer rights that more than what you need to make things happen. So we're going to talk about the whole gamut of decision making with kind of a focus on guardian advocacy because that is the least restrictive court supervision. There's some other tools that are outside of court, but it does require the person with the disability to have the capacity to understand. Okay. So legal authority, I kind of already talked about it. There's early childhood, the decision makers, the parent or guardian. Usually what happens is this is when you're getting your diagnoses, you're kind of doing your early childhood evaluations in preparation for the child going to school. School age, the decision maker is still obviously the parent guardian. The supports that are in place are usually these federal supports like the IDEA, 504, the Rehab Act, medical supports, natural supports like parents. Then you go to this transition age, which is, remember I talked about the benefits cliff. That's the decision maker is the person with IDD if there's no guardian. And that really scares a lot of parents. And actually, I just also met with a bunch of educators from Duval County, and they were talking about how kind of it broke their hearts when the parents didn't have these in place, and there were issues with the IEPs, there were issues with the 504 plans, and the the person with IDD could choose whether or not to have the parent in the room with them. So adulthood decision maker is the person with IDD if there's no guardian. What happens at the time of the death of a caregiver, that's what led to me coming to the ARC and creating Life Paths, is to really kind of answer that question, what keeps you up at night, what's next, all those kinds of questions. So the supports are usually waiver supports, and if there aren't, it's the iBudget waiver or the long-term care waiver isn't an option. There's Medicaid, Medicare, but those school supports don't exist. So a lot of parents get complacent with those school supports that you have and don't realize that once the child reaches age 22, 18 to 22, and is no longer in the school system, whether it be private or public, they do not have that support of the IDEA. So so that's something to really be aware of, is that the 18 to 24 age range is really the time to identify kind of what's next for the person with IDD and make sure those decision-making tools are in place, and be prepared for the next exciting new adventure. Okay, so I use this slide because, and you guys will be getting copies of the PowerPoint, but I use this to show that even if you do your legal planning and you do your financial planning, there's all these other, I call them pillars of life that exist that you really want to consider when you're looking at decision making. So housing, benefits, medical care, relationships, entertainment, faith traditions, employment. And I really include faith traditions and entertainment and relationships because adults, I mean, how many hours a week are we working? 40, 50, 60 hours a week. There's many more hours in the day, many more hours in a week. And so a lot of times those legal and financial issues don't really address all of the time that's spent or all the time that's needed to find supports. So I want parents to really open their mind and be thinking more beyond how do I afford this, and what do I want my loved one's life to look like when I'm not around to provide that care. So decision making. So I say this, and I use this picture because everybody identifies with what this means. So it's important if you are looking at creating either decision-making documents or guardianship documents for your loved one, that you also plan for yourself, because that's really, really important. That can set the stage for your loved ones, the rest of their life, as far as the things that they love to do, allowing them to continue doing those things. So this is obviously a flight attendant, and they say, when the oxygen comes down, what are you supposed to do as a parent? Put it on yourself first before you put it on, your child. And I say this because it's important not just to do decision-making authority for your child, but do your estate planning for yourself. It doesn't matter. Estate planning is kind of a misnomer. Everybody needs it. You don't have to be, a gajillionaire to need an estate plan, especially if you have a loved one with a disability that's going to require some planning for their continued care. So it feels impossible to plan for the future, but there are some tools, and these are kind of what we're going to be talking about today: living will, healthcare surrogate, durable power of attorney, supported decision-making, and guardianship. So this is a relatively new, it passed the legislature, I believe, in 2024, and Disability Rights Florida, if they don't have a template that's on their website, they definitely can assist, because they were one of the big groups that was behind lobbying this particular legislation. It is an alternative to guardianship, and it preserves decision-making rights. It chooses a supporter to assist and not to decide. There is a little bit of a difference between that and a power of attorney. The supporter can access information and communicate decisions. It does not have to do with financial decisions. That was one of my concerns when when the legislation was going, or the bill was going through, is that I can imagine in my head a vulnerable adult hooking up with someone that says, "Let me be your supported decision maker," and then going and emptying out their bank account or something like that. So um, it is, the statute adds that this is another thing that the court has to consider already. The court has to consider whether a power of attorney or a healthcare surrogate exists before granting a guardianship. So this is another one of those documents that the court has to consider, because there is, in statute, the public policy is that you do the least restrictive. Integration with other laws, it kind of goes along with guardian advocacy, powers of attorney, IEPs. It's just another tool in your decision-making toolbox. So what's great about this is that the communications via the supporter are legally recognized. The supported decision-making agreement cannot be used as evidence of incapacity. And it does promote autonomy and independence and reduces the reliance on guardianship and preserves rights. So this is not going to apply to everybody, right? This will not apply to everybody, but it can avoid guardianship. And there's a national lecturer that goes around. I've heard him speak several times. I think he spoke at an Arc Florida meeting a couple years ago, where there was a young woman who was in a guardianship and was able to get out of the guardianship and have a supported decision maker, so that she could kind of make her own decisions. So healthcare surrogate designation. So when I'm looking at someone who is facing parents that are saying we need to get guardian advocacy, these are some of the things I ask. Is like, can your loved one or person with a disability, can they say, I want mom and dad, or I want aunt or brother, whoever, to continue making decisions for me? Do they have the ability to communicate that? Not necessarily just verbally, but in writing. Do they understand that that's what they're doing? Because if that's the case, a healthcare surrogate designation is a really great, it's a form. You don't have to file anything. They've got sample forms online, so you don't have to go to an attorney necessarily. Attorneys will probably cringe at me saying that, but it's true. You can do it. You can find it. And so what this does is it designates a person and an alternate to make healthcare decisions. We're going to talk about a living will in just a second, but it's much broader than a living will. Living wills tend to deal just with end of life decisions. Healthcare surrogate deals with everything. It takes effect either immediately once you sign it or upon a person's incapacity. What's great with the Florida form is that there's a choice. And incapacity means being physically or mentally unable to make your own healthcare decisions. So let me give you an example. It's not just because a person has a disability. Let's say, because I have a healthcare surrogate, I give it to my husband, I get into a car accident. I'm not looking at an end of life decision necessarily, but it could be that they need to make a decision as to a blood transfusion. I'm not capable of making that decision myself. My husband is healthcare surrogate because I've given him that designation. He can make that decision for me. Okay. So it's really giving somebody else the power to assist with those healthcare decisions. There's this elder law attorney who's really fantastic in Gainesville, and she was saying that as her mother was aging, even though her mother gave input as to her medical decisions, wanted to be in control of a lot of the medical decisions, the healthcare surrogate just gave this attorney the ability to make doctor's appointments and communicate and get records and do things that her mother was kind of exhausted about doing. So it really can be an effective tool. And the requirements, though, is that the person signing it has to understand what they're signing. They have to have the capacity to understand what they're signing. Okay. Living will, and this is not to be confused with the last will and testament. People get the two terms because they have the term will in it. So a living will is a document. Think Terry Schiavo, the Terry Schiavo case. Had there been a living will, the decades-long litigation would not have happened. But it only applies if you have a terminal illness end stage condition, or persistent vegetative state. Okay. And there are 2 physicians that have determined that the end is near. There's no reasonable medical probability of recovery. So think of people that are facing being put on a ventilator, life support, all those different kinds of things. And what it does is it designates your wishes for medical care and whether or not you wish to be put on life support. All right. You have to be competent to sign the documents. All right. And it does not necessarily require it requires 2 witnesses, but not a notary. I always say if you're doing a living will, a healthcare surrogate, along with a power of attorney, I say have the person sign it, have 2 witnesses, have everything notarized. It's just the formality that I think that banks and hospitals and medical professionals like to see. So I don't always think the living will, and this is just my own personal tidbit, but I don't always think a living will is as easy from the capacity standpoint for a person with a disability to sign. And that's because it's hard for everyone to kind of understand what's the difference between a terminal illness and an end stage condition or a persistent vegetative state. And how can what does that conversation look like that kind of talks about the differences? That's kind of hard to comprehend. It's hard to understand. So I always say the healthcare surrogate, which kind of covers a multitude of things. Also, that person can make the end of life decisions. So the healthcare surrogate is the who, like you're saying, who's going to do it. The living will is more of a what, telling what you want done to the medical professional. So that's how those 2 documents kind of vary. And these are all difficult things to talk about. So definitely talk with your loved one. You'd be surprised. People have varying ideas on what they want, and there's a lot of superstition around death and dying and end of life moments. So don't make assumptions that people know what your desires and wants are, and don't make assumptions that your loved one is on the same page as you. So it's always good to have. It's difficult topics, but it's important. I had a client once who we were doing her documents, and she said, I want to put in there very specifically that I will be hydrated always. And I was like, well, I think they're probably going to keep you hydrated, like no matter what. And she's like, I do not want to die thirsty. It was just this interesting thing she had in her head. And so we wrote it right in there very explicitly. You don't have to. I'm just saying, like, that was something that was very important to her. So, so you can write kind of unique individual things in there if you want to. It's not just a form. I think in the healthcare surrogate form, there's a place to write other or additional things. So there's opportunity there. But I will say that doing this work for over 20 years, that there's definitely some interesting perspectives on death and dying and superstitions around those. So, and I respect it. I'm not at any, it's just people feel very strongly about kind of their end of life, as they should. So powers of attorney. So there's several different kinds of powers of attorney. There's forms floating all over the internet, varying degrees of quality. So I do not recommend you pulling something off the internet or asking ChatGPT to draft something for you, because you do not know if those are complying with Florida law. And every state has different legal requirements for powers of attorney. In fact, Florida back in, I want to say like 2011, changed their law to designate what they called attorneys call them superpowers. I don't think they call them superpowers in the statute, but they have several paragraphs in the power of attorney form that require an additional initial. So it's not just a signature at the end of the document, but these particular powers that you're giving to somebody have to be acknowledged by the person giving the power. So like I said, That's in Florida, maybe not in Georgia, North Carolina, Tennessee, I don't know. But in Florida, they have specific statutory requirements for powers of attorney. A limited power of attorney can limit, for example, my husband's in the military. We bought our first house when he was underway, so he could not be at the closing. He gave me a limited power of attorney for the purpose of signing, being at the closing and signing all the closing documents. And that was fun because if anyone's ever closed on a home, that the package, hundreds of pages. So I got to do it twice. Not fun, but there's general power of attorney, which is usually broad financial powers. It could have a healthcare power in there as well. Any of you that are in the military, they use very general, durable power of attorney. And so it kind of covers, all different aspects of things. And all powers of attorney require formalities in signing, right? So you have to sign it, have 2 witnesses, and have it notarized. All right. So if you have 1 witness, but it's notarized, not valid. If you have a signature and 2 witnesses and it's not notarized, not valid. If it's not signed by the person giving the power, not valid. All right. So I've seen a lot of things fail because these decision-making documents fail because they didn't have the correct signatures and witness signatures. And that's incredibly important to kind of understand what you need to have. And it's not the same. Remember when I said, do everything with signature, 2 witnesses, and notarization? That's because it's easier than trying to figure out what needs to be notarized and what doesn't, right? And by the way, a lot of times banks or UPS stores will have notaries for a charge. So you can use those sources if you happen to, have a document that you're using yourself, but not one that you pulled off the internet without going over it with someone, an attorney. Okay, so durable power of attorney is really what you need to have, and durable means that it survives someone's capacity. So so durable is this weird, like what does durable mean? It just means it survives incapacity. So let's say I give my husband power of attorney to make decisions for me. That power of attorney goes into effect immediately. In the state of Florida, you sign it over the day of. My husband could go empty out all my bank accounts and take off for Mexico. And there's not really a whole lot I could do about it, right? Because I gave him that power to do it. That freaks people out, and I totally get it. But in Florida, they don't have what they call a springing power of attorney that only comes into play when the person reaches incapacity. But durable just means that, for example, I give my husband power of attorney. We're rocking and rolling. Everything's great. I am now in the hospital because of that car accident, and I am under general anesthesia, and I usually pay the mortgage out of my bank account solely in my name. So my husband, because I'm incapacitated and we have a durable power of attorney, can make that payment out of my individually owned bank account to the mortgage company on my behalf. All right. And I'll answer questions. I see that it keeps popping up that there's more chats. So I'll try to get to these things when we're kind of at the end. So power of attorney has to have this language in it, or else it's not really durable. All right. So it says not affected by any physical or mental incapacity or disability that I may suffer, except as provided by statute and exercisable from this date. This is kind of the statutory language that that the legislature came up with to be included in all durable power of attorney forms. Okay, guardianships. So a guardianship, what I've been talking about previously are all documents that can be signed, witnessed, notarized, executed outside of the courts. In Florida, it is not required to file any of those documents with the courts, and there are some states where you have to file them with the registrar in the county where you live. That is not the case in Florida. Guardianships, on the other hand, are court interventions. And the goal is to usually avoid them if you can, right? Remember, public policy, state of Florida, least restrictive. But it is a formal fiduciary relationship that can only be given by the court. It requires the filing of a lawsuit. This is all guardianships. And it usually involves a petition for incapacity, a petition for appointment of a guardian, application for guardian, background checks, credit checks. Now, there are exceptions. We're going to talk about what those exceptions are in the next several slides. But generally speaking, if you are filing for a full plenary guardianship, you are filing a lawsuit to determine incapacity. That triggers the three-person examining committee to do their own independent examinations and file them with the court. And then you have the petition to file a petition to appoint the guardian. And so think of the incapacity as whether the guardianship is needed, and then who the petition to appoint the guardian is, who the guardian is going to be. It's different with a guardian advocacy because the basis for a guardian advocacy is not incapacity. It is whether or not the person has an intellectual or developmental disability. Okay. So some jurisdictions make an exception for guardian advocacy regarding the background and credit check. So some of you already have guardian advocacy and you're like, I didn't have to do that. It's probably because you were in a jurisdiction where the court has kind of said, you know what, you're the parents, you've been doing this for a long time. You know, I'm not really worried about doing the level 2 background check or credit check. You do, however, in the application need to be honest about things, right? I had a client one time who had a criminal thing on their background, and the attorney ad litem found it before I did, and I was mortified because here I'd filed this application. It wasn't me swearing it was true and correct, it was the client, but still it was embarrassing that I just didn't really think to do my own background. I learned my lesson. And so when I asked the client, I said, well, why weren't you forthright about that? And she's like, well, I figured you'd find out about it sooner or later. And I'm like, no, that's not. So there are some things that you should disclose on your application, right? Whatever they ask you, you need to disclose and be honest about it, but it won't necessarily keep you from being the guardian advocate. What may keep you from being the guardian advocate is the court finding out that you're lying on a sworn court document. That's a problem. All right. I had a client once too. It was so sweet. She was becoming guardian over her mother. And I was asking her if she'd ever been arrested. And she said, yeah, I was arrested for protesting in the 1960s. And I'm like, you're going to be fine. I don't think they're going to make you not, like, she wasn't like a felon or anything. So it's good to be honest. It's not going to keep you from being the guardian. Okay. Other things will keep you from being the guardian. Honesty is not one of them. So the types of guardianship, plenary, I already mentioned that term. It just means full or complete. So if you think of all of the decisions that you can make for a person, over person, over property, residence, healthcare, social, money, real property, plenary means all of it. Limited, remember, is usually only certain powers are removed and given to a guardian. I had another guardianship where the adult protective services have been involved, reached out, said, we want, out of these poor adult children, we want this one to be the guardian. And the father who we were getting guardianship over was really kind of pushing back, saying, you know, I want to maintain my freedom. I want to maintain my autonomy. And so his attorney advocated that it become a limited guardianship. And so we kind of went through the different powers and we kind of picked the ones that he wanted and could maintain control over. And then we went over finances was a big one that the son needed to be responsible for. So you can do a limited guardianship, just like you can do a limited power of attorney. Over person, a lot of guardian advocacies are over person only, especially if you've got an adult child who's only 18 and doesn't have any of their own assets. So over property is generally money, real property, investment accounts, those kinds of things. And a lot of our kiddos who are reaching the age of majority haven't even applied or gotten a determination for Social Security. So that's not really as relevant. A voluntary guardianship is the person actually has to have capacity. I don't see them that often. I saw one recently, and I've done one in my 28 years of practicing. So they're not that common, but it's the person has to have capacity, and it is only for financial powers. It's not for anything else. And then guardian advocacy, which I think is the crown jewel of all guardianships. Why do I say that? Because it is specifically for people with intellectual and developmental disabilities. It does not take away someone's legal capacity formally like a plenary guardianship does. And it kind of is tailored really to people with IDDs. So it is the least restrictive form of court guardianship that you can do. Okay. And I will say this too, because we'll talk about this next time as well. Powers of attorney are fantastic for day-to-day stuff. The Social Security Administration does not recognize a power of attorney. They will recognize a guardian advocacy and a guardianship. So a lot of people will say, well, why do you need one if you can do a power of attorney? Well, you might run into difficulty with other government systems. Now, obviously with Social Security, you can become a representative payee, but that's obviously a process. It can be changed. I just think that a guardian advocacy is just the least restrictive, but most protective option that you may have. Okay. So I just went over all of this. So I will say this is kind of tricky. There's no formal order finding incapacity, but there are a list of rights and an assignment of them to the guardian advocate. In effect, it's taking powers and kind of removing them and giving them to the guardian advocate. With guardian advocacy, it's under Chapter 393, but it refers back to the regular guardian statute, which is Chapter 744. Okay. You may, depending on your jurisdiction, have to continually go back, just like in other plenary guardianships, have to do an annual plan and an annual accounting. Judges have the discretion to waive those, but you have to ask for it. So a lot of times attorneys will make that as part of their petition that they file. So it's very important to ask for those things to be waived. It just makes your life a lot easier. And there are some judges that just won't do it. And every jurisdiction is different. So if you're coming to me from South Florida, I know there's a bunch of judges down there that won't waive anything. You got to come back every year. When I say come back, you don't have to come back to court, but you have to file documents every year and they just will not waive it. We're very fortunate in Northeast Florida where our judges generally will waive. They definitely waive accountings, especially for people that don't have any assets, but they may or may not, depending on the age and circumstances of the case, waive the annual plan. But just because an annual plan isn't waived initially when that guardian advocacy is initially completed, you can, after several years, come back and ask for that annual reporting to be waived. And I've done that for families as well, where I've asked for it to be waived. It's not waived. We do the annual reporting for several years. We have evidence. We're showing that there's not a change. So there's no reason to really have it. And so usually that is granted by the court. So there's ways around that. So I am not going to go over the process so much for guardian advocacy. I feel like that's a discussion for another day. I will say that a lot of the work is the documents, meaning that it's gathering the information, filling out the petition, filling out the application. You have to do a You have to do an oath and designation it's called an oath and designation. It's a form. There's a lot of it is very form driven. Once you get to the actual hearing day, it's like 5 minutes on Zoom. And then you're like, what just happened? Right. So many parents would be like, that's it. Yeah, that's it. So, but this is kind of going back, we're coming full circle to kind of the beginning of the presentation where we're talking about the different kind of, the phases of life and also all those different things that go beyond financial and legal planning that you want to have for yourself or your loved one with a disability. So this kind of is a timeline because parents are like, when do I do this? When do I start? So, as a decision maker for a child who's under the age of 18, if you haven't applied for APD services, or you have applied and were denied, but your child is hurtling towards that 18, now is the time to apply or reapply. Okay. And get your diagnosis, get your paperwork, get your IEPs from school. They require so much. It is important to do that. If you're already on the wait list, you've already done what you need to, right? I'm sorry, pre-enrollment list. Lay people, we all call it the wait list. But if you haven't applied, do it before age 17. It really is with the APD, if you don't have those documents that you need, if the diagnosis hasn't happened prior to age 18, APD has generally denied that, even though it's a developmental disability, right? We know it's developmental, that it happens from birth or soon after. It doesn't matter. They kind of have drawn a line in the sand, basically saying the diagnosis has to happen before age 18. Right now, you're seeing a lot of people saying, I didn't realize I was on the spectrum until I was 30 and I got a diagnosis. Those people would not get APD services. They might be too high functioning anyway, but I'm just saying, like, you have to have that diagnosis before age 18. If you are given the option to defer the diploma to receive transition services, do it. Okay, this is usually in the senior year or the 12th year, so please defer. It extends the protections under the IDEA. You have that continued option to use the Florida Empowerment Scholarship until age 22. You get to stay in school until age 22 if you have the option to defer. So, to me, it's not even, if that option is presented to you, I say take it because you have 4 more years of figuring out. You get, usually between the 18 to 22, the schooling is less academic and more about preparing your loved one for, life out in the community. So it's some very valuable things and different kinds of programs. So there's private programs, there's job focused programs, there's more day program like transition programs. So we've got ones in our center schools in Duval County. I'm sure there's center schools in other jurisdictions. And then a lot of high schools or private organizations have their own transition programs. So I say defer. At 17 and a half, begin the guardian advocacy process. That may even be too late. Look at 17, right? 17 years old. You do not have to do it at 14. Some parents, they start talking to parents about guardianship at age 14. When their child is age 14, you can't get it until they're really right before or right after the age of majority. So I say anywhere between 17 and 17 and a half, begin that guardian advocacy process. It does take time, okay? At 18 years, 1 month, apply for SSI. And so why is it so specific, 18 years on 1 month? That's because Social Security looks backwards. So when you get paid on December 1st, it's the November benefit, okay? So they will not take an adult application for SSI until that person is an adult, okay? And then at age 21 and a half, you need to let APD know about the completion of the transition program. If you followed our advice of deferring the diploma and your child has been successfully completing their transition program. At 21 and a half, you can let APD know, and it moves you up on the 1 through 7 categories if you're on the pre-enrollment list. Also, don't assume that people know your business. Okay, I mean that in that you apply for APD, you put, probably as a caregiver and a parent, you put down your date of birth. They're not going to keep up with it. There's not some kind of alarm clock going off at APD telling them what's happening in your life. Just assume they know nothing and keep them up to date, right? Let them know your child's 21 and a half. They're about ready to complete transition program. Let them know that if you're a caregiver age 60 or over, they do not keep track of who's 60, who's 65, who's 70. They don't even really keep track of addresses that well. So update your address if it changes. Update your phone number if it changes. So it's one of those things where don't make assumptions that these state agencies are keeping up with your demographic information or necessarily talking to each other, right? So you may apply to something on DCF and put all that information in. They may not share that with APD. Maybe they did. I don't know. Did they share it with ACA? Who knows? I will say one of the things I think would be fantastic. There are some states that have implemented from federal direction and federal grants, implemented kind of this comprehensive information sharing amongst state agencies. I really think Florida would benefit from that, but that's an aside. I just think it would be better if everybody worked together, and most common citizens just assume that the government is talking to each other because it makes sense, right? They're all part of the executive branch, but they're not. So just keep that in mind. So for next time, and I'm going to leave about 10, 12 minutes for questions, but sneak peek for part 2. I hope you will join us. As you can see, I'm keeping with the cliff and but this one's positive because they're climbing up, right? We're going to be discussing applications for Social Security, working while disabled, the role of representative payee. Remember, we talked a little bit about that today as part of the decision maker information. How Social Security benefits interact with Medicaid and waivers such as iBudget Med waiver. So stay tuned until Wednesday, December 17th at 12 noon. And I will be here to kind of, I call it hot topics in Social Security because Social Security is so complicated. There's no way that I could cover even a smidge of it in an hour. So we're just going to really kind of hone in on those things that affect that transition age and support parents in helping their kids maintain either get or maintain their benefits. So let's look at questions.
Thank you, Sarah. Yeah, you went over a lot of great information. So we did have a handful of questions pop up in the chat. And then after we go through those, if anybody missed anything, if you have a question, please feel free to ask. So I'll just start at the top. Miss Lee asked, can you provide clarification regarding the status of a property advocate? Is this individual regarded as a legal representative?
Sure. So I think what this means, so you can have a power of attorney that is over property and financial, right? You can also have a guardian advocate or a guardianship that's over property only. So it's when you are with the power of attorney, the person that you give the power to, like let's say I'm giving my husband the power, right? I use him as an example because I use my family, they love it. But anyway, so my husband is the attorney in fact. That's the technical term for it. He's the attorney in fact. He's not necessarily my legal representative, but he has the legal authority based on that power of attorney, what's in there, to make those over property decisions. Similar with a guardian advocacy, remember you have the decision-making tools and then you have the guardianship, which are the court-appointed powers. So in a guardianship over property, guardian advocate over property, you are a court-appointed legal representative, but the terminology is you're their guardian advocate. So I think there's so many different terms, and I know this gets. What I might do before we send it to everybody is I might do a terminology sheet, which might help kind of clarify some of these things.
Okay.
So if you're dealing with financial powers from a document, like a power of attorney, you're the attorney in fact. If you are doing it through a guardianship, you're the guardian or guardian advocate. In government benefits, Social Security calls them representative payees. I believe like ACA, DCF, and Medicaid, and DCF and APD have legal representative forms. But I believe if you're the guardian advocate, you're also considered the legal representative for purposes of APD. I hope I made that clear and not more confusing.
Well, I think that led into her second question, and you answered some of it already, which is what are the decision-making parameters for this type of advocate? I think you kind of already hit on that.
Yeah, I'm going to sound like an attorney, but it's kind of it depends. In a power of attorney, you can draft all kinds of things in there. You can limit things, you can put things in there. With a guardian advocacy or a guardianship, the court has specific, and it's usually by statute, but powers that are included in there. So if the person with the disability, it has the capacity to sign the power of attorney, they also have the ability to expand or limit what kind of powers you have. Whereas in a guardian advocacy, the judge is controlling what powers are removed and conferred on the new guardian.
Thank you, Sarah. Miss Lee also asked, how do you become a SDMA?
So that is similar to a power of attorney in that the person with the disability designates who they want to be their supported decision maker, and they fill out a form. And I believe sample forms are available at Disability Rights Florida. And I think if you go also, they usually have SDMA. I'm doing a plug for Family Cafe, and they don't even know it. At Family Cafe, they usually have a couple of sessions on supported decision making. And I know that their Nova Law School has a clinic, and they come up and do those during Family Cafe. So there's opportunity if you want kind of somebody that has experience doing them. There are ways in which to get them, but it's a document just like a power of attorney or a healthcare surrogate.
Okay. Thank you very much, Sarah. Naomi asked if two people live in two different states, are they able to sign together still?
Are we talking about? I probably need some clarification on that.
I
So
assume for
if
power of attorney, all she
right,
said was if two parties live in two different states and cannot
if
sign
Na-
at the same
yeah, if Naomi's still on, if you can clarify, is it the person applying to be guardian or is
for,
it the
for power of attorney.
power of attorney? Okay, so the power of attorney, uh, usually Florida powers of attorney are for people that are living in Florida. Um, if I'm going back to my military, which the military powers are kind of universal. Florida is no matter where you get your power of attorney, if it complies with Florida's formalities, it's valid. Okay, so everybody needs to all be there when you're signing your, if I'm giving my husband power of attorney, he needs to be with me, the two witnesses needs to be with me, the notary needs to be with me, so everybody needs to physically be in the same place. Where they live doesn't matter. I could give my sister who lives in Iowa power of attorney, right? Um, and actually, she doesn't have to be in the room. Let me go back and say that. I have to be in the room, my witnesses have to be in the room, and the notary has to be in the room. Who I give the power to doesn't. You just should probably communicate to them what you're doing. So like if I give my power to my cousin who lives in another state, as long as that's totally fine. But I have to sign it, two witnesses and the notary, and we should all be together in the same place, and conceivably if it's a Florida power of attorney in Florida. I hope that answers your question. There's one more from Maria Giulietta Romano for IDD adults. for SSA, SSI, SSDI. The rep payee, when there is no legal guardian, is important to identify. So yes, you can have a person that has no guardianship, but they have a rep payee, because Social Security is a purely federal agency. They will recognize a guardianship, but it's not required to have. And there are people that need rep payees that don't have guardianships. So we'll talk a little bit more about that next time. But yes, with the rep payee, if you are the guardian, it makes sense to have those be the same person. I can't imagine why there wouldn't be, unless there's, like, for example, we're a corporate rep payee like Lutheran Services Florida or LSS. So we can be rep payee, and sometimes guardians will choose to make us rep payee because it just makes it easier. But yeah, generally, you can have a rep payee that's not a guardian, and you can have a person that doesn't have a guardianship but still needs a rep payee for Social Security purposes.
Thank you, Sarah. Naomi asked a question and then she clarified. She said, what if they just turned 17? And what she's saying is, quick background, I am getting my 17-year-old granddaughter and we are doing a power of attorney. So I guess she was just asking for some advice about that.
She has to be 18. She can't sign it until she's 18 years old.
All right.
She has to be an adult, because children under the age of 18 are considered incapacitated due to their age. So once she turns 18, she can sign those documents, but you are considered incapacitated in the eyes of the law until you become an adult, not because of your disability, but because of your age. I'm so glad you brought that up, because I didn't talk about that. Thank you, Naomi.
And then Molly asked, can divorced parents be co-guardian advocates if they're of their disabled adult child?
Absolutely, they can. They can be co-guardians. You can have one that's the primary guardian and one that's a standby, which the standby doesn't have any powers, but they're kind of waiting in the wings, so to speak. I will say that the better you are at co-parenting, the better you're going to be co-guardians. So if it's like a hotly contested kind of proceeding and you guys don't agree on how things should be, that can be difficult for a guardianship, because you're going to have to be going back to court to get things approved. In that particular situation, they don't look at like what's in the best interest of the child, and they don't look at all this, divorce, Chapter 61 things that you do when you're doing a parenting plan for a minor. But what they will do is the court may consider that one person is kind of the best person to be the guardian, and then the other person can be standby, or you can be, if you're really good co-parenting, which is the ideal situation, you can absolutely be co-guardian advocates. I've had step parents be guardian advocates. So parent, step parent, and then the other biological parent has just said, I'll let them do it because they do a good job of it.
Well, thank you very much. I appreciate you answering that. So, Marilyn gave us a situation here. So, consumer age 39 lives alone in the parent home. Him and his sister names are on the property. The only thing the sister helps pay is taxes on the home. The consumer pays everything else. The sister lives in another state and is now telling consumer he can have no one at the home without her permission. The sister has no power over him.
Yeah, I'm not sure if this is so much if the consumer is 39, that's probably more like a real property issue and not so much as a decision making based on what's been presented by Ms. Williams. This 39-year-old has full capacity to make decisions. So unless there's something to the contrary, it looks like they're maybe joint owners of the property. So that might restrict what the 39-year-old can do with it, but that's probably more a real property issue for somebody with full legal capacity to make those decisions. It's less a thing of the sister having power over the 39-year-old and more the fact that they're both on the deed, so they both have certain rights and responsibilities to the property. So I would seek a real estate attorney.
And then Miss Lee had another question. Is a handwritten power of attorney that is not notarized legal? My client's stepmother has been using this status for years and the APD has honored it.
Um, so there, like I said, remember I said there's lots of stuff floating out there. So powers of attorney in Florida have to be, I mean, handwritten doesn't really matter. Handwritten typed, obviously typed is easier to read, but it has to be signed by the person giving the power, witnessed by two witnesses, and notarized. All right, in order for it to be effective. Whether or why people are honoring this, I do not know. But based on what you're telling me, if it's like a handwritten note on a cocktail napkin and it's just been signed, I'm not saying it's on a cocktail napkin, but it is not valid. I'd have to look at it myself, but based on what you're telling me, if it's not witnessed and notarized, it's not legal. Now, if it's a healthcare surrogate and it's signed and witnessed, it's fine. Not required to be notarized. I just think it's better to be formal.
I'm not sure if this is a question that applies to our meeting today. Mary asked, but I could be wrong. As homeschoolers, are there any resources for transitioning that apply to our 17-year-old? She had a 504 in public school.
Oh, so that's probably it is kind of related to what we're talking about
Okay,
today because we are
I
talking
wasn't
about
sure.
decision making, yeah, and transitioning. I'm gonna say my quick answer is I don't know because I'm not an education attorney. But and there's some really great resources out there that can kind of give her some feedback. I think it depends on um homeschooling is such a wide range of things. Like, for example, you can do homeschooling and choose like Florida virtual or, county, like our county has virtual. And I think it probably would be more traditional in what the rights and options are. But I really think IDEA does, a lot of it kind of stems around that diploma and whether or not it's deferred. And so I would encourage you to find an educational advocate. Mary, if you feel comfortable disclosing it, what part of Florida are you in? If she can tell me. And
Some,
where's Summerfield? Defer diploma. Okay. So if you defer the diploma at Marion County, okay, great. There's actually there are probably some pretty good resources in like Ocala, Marion County area. So if you defer the diploma, then you still have those protections, I believe, up to age 22, and that means you can continue on if you're getting that Florida Empowerment Family Empowerment Scholarship that can continue. Just make sure that she meets those requirements to defer. Once you've deferred, you can tap into those transition programs. You can, that can pay for a multitude of different things. You've got lots of flexibility since you're homeschooling. But I would talk to because it can get kind of tricky with homeschooling. I would definitely talk to an educational advocate or education attorney. There aren't that many of them in the state of Florida, but what I can do is get some resources on Marion County to Arc, Florida, and they can reach back out to you and get those to you.
yeah, absolutely, Mary. Just like everybody else, we'll get a recording or a copy of the recording for this meeting, and all the resources from this meeting. So if she needs anything else, she can just shoot us an email and we'll make sure that she gets it. Yeah. And yes, so just like every meeting, which I'll just go ahead and say, Sarah, I appreciate you so much. Thank you for answering all those questions and thank you for your presentation. I know that you're going to be sending us some things that we can send out, but yes, we'll send out resources from this meeting. We'll send out the link to our YouTube, where you can find all of our recorded meetings. And for all of our meetings, if you would like a certificate of attendance, then you can send that request to me by email. We don't send out certificates automatically. But all right.
Any other questions? No?
Definitely appreciate you all taking up your lunch hour to be with us.